Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. The only thing worse than a stupid client is a client that thinks they're smarter than they actually are. And today we're talking about Jesse Kurczewski and the case up in Wisconsin. For those of you who may have been in a cave in Afghanistan for the last week, it seems that Ms. Kurczewski is alleged to have written a letter and had it smuggled out of the jail by her attorneys, and the letter was actually delivered by the attorneys, again, according to investigators. In fact, let's take a look at what's been alleged here. The letter was written to a friend who Kurczewski knew, and according to Channel 58 up there in Wisconsin, in the letter prosecutors believe Kurczewski wrote, she said her lawyers were in on the scheme and delivered it for her. And indeed, when they checked with the postmaster, they were able to determine that the letter didn't go through the postal system. So there is some, possibility that someone in this law firm helped Jesse Kurczewski do this thing. Now, one of the things that people who are narcissists and people who are manipulators, and I think that's probably a fairly accurate description of Jesse Kurczewski, is they identify early on the people that they can wrap around their little finger, and they push them to break little rules, and then the more experience they get breaking little rules, at some point they push them to break a big rule. You absolutely can't smuggle correspondence out of the jail for your client. That's a big no-no, and that can get you in trouble. And you have to understand, this is probably not the trial lawyers who represented her at trial. This may have been a paralegal. This may have been someone who took some document to the jail for Kurczewski to sign, and Kurczewski said, hey, will you deliver this for me? It's personal, and I just don't want it to go through, the jail system. And of course, that sounds pretty reasonable on its face, and if you're a paralegal and you don't really understand the rules that well, you might very well be inclined to make that mistake, even though it's a huge mistake, and it's a huge mistake for the law firm. So when this is revealed, and it's revealed in a filing by the prosecutors, the first thing that happens is Kurczewski's lawyers say, hey, we want out. And they have good reason to do that. And in fact, the rules allow them to do that. Let's take a look at those now. So these are the rules that regulate the conduct of the bar in Wisconsin, and there is a rule with regard to confidentiality. And that starts with the general paragraph that, we don't reveal things that our clients tell us that are confidential information. And we can only reveal anything that we can reveal only with their consent, except as stated in paragraphs B and C. So what do B and C say? Well, a lawyer shall reveal, meaning there is no discretion on the lawyer's part. A lawyer shall reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to prevent the client from committing a fraudulent or criminal act, and the lawyer reasonably believes it is likely to result in substantial bodily harm or death, or in a substantial injury to the financial interest or property of another. Well, if you think about that, she's asking this person to violate the law. In this letter, what she asked her to do was help her cobble together some documents that she could say that she watched the trial on TV, and as a result, she put all this stuff together. And she's going to send it into the court and convince the court that, Kurczewski is actually factually innocent. Don't think there's much chance of that happening, but people who are stupid enough to commit murder are stupid enough to believe that in this magical thinking that all they need is one forged document to get them out of jail, without realizing that all one forged document is going to do is not only keep them in jail, it's probably going to put their friend in jail right next to them. So this is, in many respects, the prevention of substantial injury to this friend. Now, because the lawyers did not reveal the letter, they would even if they had revealed the letter, they would certainly be able to withdraw on the basis of the fact that somebody in their firm is alleged to have committed a criminal or wrongful act by, delivering this letter. But now they also get to reveal information that is necessary to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, to establish defense to a criminal charge or civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of the client. So now, obviously, what the lawyers want to do by withdrawing is have the ability to go to the prosecutors and say, essentially tell them what happened, that there was no intent to violate the law here, assuming that there was no intent to violate the law, and that it was a huge mistake and, they're terribly sorry. But all of this is governed by the confidentiality rule, and without withdrawing, there's no way they can really do this in real time. They'd have to wait until at some further point. And you have to understand, a lawyer's representation doesn't end just because the client gets convicted. They're going to go to jail, no question about that. But there's post-conviction relief. There's a motion for new trial. There are appeals. That doesn't mean the lawyer has to represent them in the appeal. And it doesn't mean they have to represent them in the post-conviction relief proceedings. In fact, in most cases, you want a different law firm doing it, simply because there are things that might have been missed by the first set of lawyers. Now, personally, I think the lawyers who represented her did the best job they could with the rotten facts that they had. And so I think she was very ably represented. She doesn't have a claim for ineffective assistance of counsel here. But this is at least partially what she could be trying to set up here. My lawyers ratted me out. That's going to be her claim. When in fact, it was her friend who took the letter to the investigators, which I find interesting, and it tells you a little something about how her friends now sort of think about her. Now, there's also a rule that governs how you decline or terminate representation. And it says, a lawyer shall not represent a client where representation has commenced, shall withdraw from representation if the representation will result in a violation of the rules of professional conduct or other law. Well, the rules of professional conduct say that you can't help a client further a crime or a fraud. And so that means that termination of the lawyer-client relationship is allowed in that circumstance. Except as stated in paragraph C, a lawyer may withdraw from representing a client if, 1, withdrawal can be accomplished without material adverse effect on the interests of the client. So there's already a conviction. The only thing that remains is post-conviction relief and an appeal, and that could be handled by another law firm. So again, it's not a significant impairment on the lawyer-client relationship for them to withdraw at this point. 2, the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. Well, when you're asking a friend to populate the court record with false documents, that I think is a pretty good indication that perhaps you're acting in a criminal and fraudulent way. and so that also would give them grounds to terminate representation. Or if the client has used the lawyer's services to perpetrate a crime or a fraud. Well, going outside the mail system in the jail is probably at the very least a misdemeanor, and trying to populate the record with false information is definitely a fraud. So that's good. Plus, there's other good cause for withdrawal, which means that essentially the relationship between client and lawyers has deteriorated to a point that they don't believe they could be effective in representing her. Yesterday, Judge Doro, God bless her, I love the judge, but she sort of went through this long and involved harangue about what she had to do and what she needed to do and how there could be an appeal, and she didn't want to create appellate issues. And I am reasonably certain that her reliance on the rules, she relied on the very same rules that I found, and she made the right decision to allow them to withdraw, because at this point it is not going to affect the outcome of the case. Kurczewski will get new lawyers appointed for the purpose of handling sentencing and appeal and post-conviction relief. All of that will happen, and it'll happen with new counsel. And the people who represented her will be thanking God all the way back to their office, because it is not a good deal when you're dealing with somebody who's just not rational. Now, if you're silly enough to commit murder, right, and you're stupid enough to believe that you could set this giant fraud up and make it look like she killed herself and you would never get caught, well, you tend to have magical thinking. And one of the problems with magical thinking is it never works out for you. And indeed, that's exactly where she is right now. It has not worked out for her. And it's not going to work out for her. But the judge made the right decision to allow them to withdraw, and she also made the right decision to allow the sentencing to be put off until she is competently represented. And that's going to take 3 or 4 weeks. It's going to take some time for another lawyer to come in, read through the record, assuming they didn't watch the trial, read through the record, read through all the motions, look at what the sentencing guidelines call for. And I'm pretty sure they call for life without parole in Wisconsin. But whatever the guidelines call for, that's where she's going to be. This judge is not going to deviate from the rules. She's not going to deviate from the statutes. She's not going to go to a lower level because she thinks there might be a possibility that this girl is innocent, because the jury said she's not. She made rulings. They were good rulings, but all rulings can be appealed if you're aggrieved by them. And so she has to allow this person to have effective representation at sentencing, and she has to allow her to have effective representation on appeal and post-conviction relief. And that's what is going to happen. So Judge Doro did all the right things. I believe the lawyers probably did all the right things here too. I don't know if we'll ever know who it was that actually took this letter and hand-delivered it to this friend of hers. But we can thank the great good Lord that that person looked at that and said, "Whoo, boy, I don't want any part of this," which is exactly the smart thing to do. We used to get calls from the jail at our office because we were there in Jefferson City, Missouri, and the state prison was there. And we get calls from prisoners all the time. "Will you represent me on a habeas corpus?" And in most cases, our rule was, we'll represent somebody on a habeas corpus when the Supreme Court appoints us to do that. And the Supreme Court did appoint us to represent people at different times. But other than that, because once it goes to the Supreme Court, it has some indicia of being perhaps meritorious. And so in that situation, we would. But otherwise, what you do is you wind up getting into a relationship with a client who is incarcerated, and they immediately start pushing you to do things that you absolutely cannot do. And even though you start out the relationship by telling them, "I'm your lawyer, I am not your courier, I am not someone who procures cigarettes or other contraband for you, I'm not going to get you a cell phone, and that's the way it's going to be, and if you don't like that, then you need another lawyer." Unfortunately, people that lawyers often rely on, secretaries, paralegal staff, some of them don't have the best education. Now, the paralegals that I worked with were great. They would know not to do something like this. But not everybody does. And a lot of times, soft-hearted people wind up being soft-headed people, and they do things that they shouldn't do. So we'll have to kind of follow this and see where it goes. Kurczewski denies writing the letter. It's very clearly in her handwriting. She managed to include her attorney's notes in with the letter, and the attorneys identified those in open court and said, "Yes, those are our notes, and we do believe she wrote this letter." So it's probably another felony to do that, and we'll have to see what happens. Anyway, that's what I have for you today. Not exactly a happy case, and it's certainly ridiculous to be doing this at this end. You would think that if she wanted to set up a defense, she would have set it up before she got convicted, not after. But again, magical thinking, narcissism, self-interest, they allow people to think things that are clearly contrary to reality. And they're not crazy, they're just deluded. So, if you have any questions, put them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. And if you would like, you can certainly email me with a comment, and I will try and get back to you. Thanks again for watching this video, and come down and see me at the beach tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.